I want to start off by telling you that this session might seem like a departure from what we've done before. And in some ways, I guess you could think of it that way, but I don't really think it is, and I'll explain what I'm talking about. This time, I want to talk more about what was happening personally in my practice, what kind of work I was doing as a psychiatrist, and how events caused it to shift in it ended up being a rather dramatic shift. Not anything that I ever intended or could have anticipated, more or less my just responding to if I get a phone call from an attorney who has a proposal or an interest in my possibly participating in something, I check it out and see. And a series of events happened that I want to tell you about because it'll give you the background to more adequately fully understand the subjects that we're going to talk about in the next few sessions, which is people being accused of sexually abusing a child and whether or not there was real evidence that they'd ever done that and all the consequences which flowed from it. I think we'll all agree a very, very important subject. All right, so to begin that, I recommend you focus yourself on the year 1985. I'm going to tell you about what my professional life was like at that point and what it had been for the few years preceding it as a background to then telling you about what came along which changed everything. In 1985, I had been practicing in the Bay Area for 12 or 13 years. Initially, I was with the Kaiser Medical System. I then switched over and got a job that I had originally wanted to get with the county mental health system as the head of the emergency division of Marin County Mental Health. And then I went into private practice. I gradually had concluded, and this is a subject for a whole other session, I had gradually concluded by 1973, let's say, that I was not comfortable practicing any involuntary psychiatry. Under no circumstances, I did not feel I wanted to do that. I thought I could help more people by avoiding that. So I went into private practice. And I had been in private practice since about 1973, working out of my home. And in addition, my interest and growing experience in certain legal situations had led to a variety of cases in which I was playing a role studying and then testifying in those cases. Now, if you've really been on your toes in the previous sessions, you'll immediately should have a question. Well, I thought, Dr. Coleman, you didn't think psychiatrists should be in the courtroom. That's exactly the kind of question I hope you are bringing up. My role in those cases, which I haven't even told you what they are yet because they're too much to get into this session, but in this variety of cases, I never gave opinions about the state of anybody's mind. I was always giving opinions about the state of psychiatry, the methods of psychiatry, the tools, the conclusions of a particular doctor or doctors by studying what methods they had used, and then giving my opinions about the nature of those methods, not the nature of anybody's mind, past, present, or future. So there really wasn't any inconsistency, even though I was a courtroom psychiatrist. I was not examining individuals and then supposedly determining the things which I don't think we know how to determine. Now, the most outstanding example of those kind of cases were cases in which prosecutors had called me, and they were prosecuting an individual where they knew that the defense was going to enter a mental defense, either an insanity defense or a diminished capacity defense. And as you may recall, that is where the defense would admit that the individual had committed certain illegal acts. But what the person was potentially guilty of, if proven guilty, also depended on what state of mind they had at the time. Narrowly defined states of mind. It wasn't just were they depressed or anxious. They had to either not appreciate what they were doing was wrong because of mental illness, or not be capable of conforming their behavior because of mental illness, or not meaningfully and maturely premeditating or deliberating, as we talked about in other sessions, the so-called diminished capacity defense. So the prosecution, in anticipation of that kind of testimony from defense experts, having heard about my work through articles, radio, TV, and other kinds of sources, decided not to call an expert who would use the same methods as the defense's psychiatrists or psychologists, and then find somebody who just reached a different conclusion. That's the standard way of doing it, even to this day, but had decided, maybe based on my having lectured at some place and they learned it that way, that they were going to call me instead to talk about the methods of the field and to try to nullify the impact of the defense expert in that way. They first called me for that in 1975. Now that's 10 years before the year I gave you in the beginning of this session, 1985. So I had, by 1985, 10 years worth of testifying on behalf of the prosecution in criminal cases involving the alleged mental state of the accused as described by the defense experts. And my work was to talk about those methods and explain to the jury that, in my opinion, the methods were worthless. They were actually worse than worthless. Number one, mental health professionals are biased in favor of the people that they interview. It's very hard to rid yourself of that. We're trained as physicians. We want to help people. But number two, the main thing is there aren't any tools for determining with psychiatric expertise whether you had a particular intention, whether you premeditated or understood it was wrong. And what I told the jury is, besides, you already have the right method. The right method is decide what you think the facts of the case were, the behavior of the individual in the context of the evidence as you decide it to be. That will tell you whether or not the person did or didn't have the state of mind that the court, the trial, is interested in. Okay, so that was the background. And my practice in 1985 was anywhere from 12 to 15 private psychotherapy patients. And in addition to that, I had a smattering of legal cases of a variety, not always this prosecutor type of case, but a variety of other kind of cases. Maybe in other sessions we'll get into it. But all of them had to do with what I consider to be unscientific and unreliable methods from psychiatry and psychology that were being called by the other side, and I was going to explain what those methods were. I had been doing these cases with the prosecution, seeing private patients, and a smattering of other cases. In 1985, I got a call from a defense attorney. And the defense attorney told me, "Dr. Coleman, I know your work well. As a matter of fact, you opposed me in one of my cases where you were able to help the jury or convince the jury that my insanity defense was not very believable. So I know what you think of some of these psychiatric methods. I've got a different kind of case now that I wonder if you'd be willing to study. It's a case where there's an accusation against a father that he sexually molested his child, 7-year-old. He adamantly claims that he didn't do anything. I believe him, but obviously what I believe is not the point. I wonder if you'd be willing to study the case and tell me what you think of some of the kinds of things that the prosecution intends to bring into the case. For example, Dr. Coleman, they've been talking about a thing called the accommodation syndrome, written by a psychiatrist. And I don't quite understand how it's supposed to help, but they say it does. And also the way the child has been interviewed. We have videotapes of the interview of the child, and we have some problems with that, and we wondered what you think. So I told the attorney, well, I've never heard of this accommodation syndrome. It was a Dr. Roland Summit, the name that he gave me. I'd never heard of that name either. But I can tell you, this is now Lee Coleman talking back to the attorney, I can tell you there isn't any syndrome in psychiatry that is of any help in telling you whether somebody committed a crime or committed any act, non-criminal act. There isn't any behavioral pattern of somebody's past that would tell you whether they did something later on. So if you want me to look at it and get a little more, tell you what I think, I'll be glad to do it. Well, without going into the details of that case, I indeed found many, many problems, which we will go into in the next few sessions, with what Dr. Summit had written, the so-called syndrome. It didn't do anything to assist a trial in determining whether somebody had done anything, and seriously, seriously would hinder any such effort. And the interviews indeed were highly troublesome, and I will go into that. But for this session, I want to just go on and then describe what then ensued with regard to my work as a backdrop for what we're going to go into a little later. As a result of that first case, and then that attorney, of course, telling other people of his experience working with me and what happened in the case, I began to investigate more about the things that I had seen in that case. I got the article, of course, prior to my testimony, this article on the so-called accommodation syndrome, and studied that article, learned about Dr. Summit's work in general, what it was and what it wasn't. And I began to study where the methods that were being used in the interviews with the children, where those methods came from, because they were highly disturbing, highly suggestive, and clearly demonstrated that the interviewers had a preordained agenda that they were going by. It wasn't any kind of a neutral, investigative kind of questioning that they were doing. So I understood that it was very important for me to find out more about where this was coming from. That's what I'm going to talk about in the next session, is where that stuff was coming from and why it's such a terrible problem that we have to this very day. But just to finish up on this one, this session, as a result of that case and a few others with other attorneys in the Bay Area who learned about me from this first one, I started reading, studying, and writing. And I learned about organizations and responses to what was going on. I began to learn that what happened in this case was very much of a pattern that was being generated by a collaboration between law enforcement, child protection, social workers, district attorneys, and mental health professions, and even pediatrics. So, of course, the center of our work in these sessions is the mental health professions and society. I don't think you'd be too surprised why my interest was focused in this way. I could see right away, the very first case, here we go again. One more example of mental health being brought into social policy and the law and totally messing it up. And what you're going to hear in the next few sessions is just how serious it has become. It more or less transformed the work that I did for the next 30 years, and I have only recently retired from accepting cases of that type, but that doesn't mean my advocacy based on that experience is going to stop now. So just one final segment is, as the prosecutors began to see that I was coming to testify with increasing frequency on behalf of defense attorneys to explain this accommodation syndrome, examine the interview methodology, to try to find sources for the biased techniques that were being used. The prosecution was now opposing me, whereas they had been my friends. That is, not my personal friends, but they were friendly toward me. They were inviting me to their meetings on a yearly basis for a while. Probably spoke before a dozen different national meetings and state meetings of district attorneys, praised as a brave and true soldier who tells it like it is. I gradually went to becoming some kind of a slime ball who doesn't care about children, who will defend child molesters, etc. I shouldn't need to go into this, but the idea that this work questioning the methodology, the biased methodology in accusations of child sexual abuse has nothing to do with one's attitudes about protecting children from sexual abuse or any other kind of abuse. So I don't feel it's necessary to belabor that point. I'll take it that you have the good sense to understand that those two are not related. So that's what we're going to go into, is going to go into the subject of allegation of child sexual abuse and how we have developed a terrible, terrible system of abuse which doesn't know how to tell the difference between children who have been abused and those who haven't, which regularly accomplishes conviction, not just prosecution, but conviction for people where there is no evidence that any person has molested the child. There might be some cases where the evidence eventually shows someone else has done something, but that's rare. I'm talking about cases where there's no evidence that the child's ever been molested, but due to adult misbehavior, perhaps starting from family members, but that's more forgivable than misbehavior by professionals, to become in the most biased way to behave in such a way that will create allegations or sustain allegations and then lead to convictions. In my judgment, we have thousands of people, I mean thousands, falsely imprisoned in the United States today, and other countries are following suit. So in the next session, I'm going to go into the way these cases work, illustrate the kind of things I'm talking about, and explain the foundations for it, where the methods came from that have put us in a system now which is so abusive of justice that does not address the issue of whether somebody has committed such an act or not in any kind of reasonable way, and hurts everybody in the process. So come back and let's go into that next time.